Welcome to RootsTech. This is our first session of the first official day of RootsTech. This is wonderful. Thank you so much.
Hold on 1 second. I'm sorry, guys. I'm still having a little technical difficulty here.
It's all right.
I know people will be.
And as you can imagine, this is a much anticipated session. And so we are glad and waiting and happy. I'm Colin Smith. I'm an employee at Family Search, and I've been coming to RootsTech for 7 years. And that's not even as long as a lot of my colleagues and friends, maybe some of you. But it's been a wonderful journey, and I'm excited for what this year has to bring.
I'm hoping that this does the trick. Okay, now what are you guys seeing? Just the slides?
Yes.
Yes, perfect.
Okay, I'm ready to begin. Please forgive me. Guys, I'm LaBrenda Garrett-Nelson, and I'm going to begin this joint lecture by talking about the many paths to emancipation of enslaved African Americans before the Civil War. And I will be followed or joined by Dr. Deborah Abbott, who will then focus on the treatment of the free people of color who managed to gain their freedom during the Antebellum period. This is just a reminder about the general law of copyright. So as shown in the table on this slide, in 1860, there were about 4.5 million people of African descent in the United States. 90% of these people were enslaved, but about 10% were free people of color. About half of the free colored population lived in historical slave states. So I'm going to begin with a focus on the paths to freedom that existed before the 13th Amendment to the US Constitution ended hereditary slavery. And then we'll be joined by Dr. Abbott. Now, because there was no common law precedent for holding someone in servitude for life, historians differ on the legal status of the first 20 and odd Africans to arrive in the English colony of Virginia in 1619. Documents such as this abstract of the renewal of a land patent suggest that Africans were initially treated as indentured servants, the same status as many Europeans who arrived around the same period. This document was filed at a time when someone could obtain land under the head right system and become entitled to 50 acres of land, normally for paying the passage of each person transported to work the land. The person making the head right claim would file a list of the people whose transport they paid. The end of this 1643 list of names of workers who provided a basis for head right claims includes 3 men who are described as, quote, Negro. So it is possible that at least some of the first Africans who were transported to what became the US mainland served a term as indentured servants and then lived as free people of color. One of the notable decisions that came out of the General Court in Virginia was the 1640 case of John Punch. The case is normally cited as setting a precedent for racializing slavery, but because it appears to have used race as a predicate for perpetual enslavement. John Punch, described only as a, quote, Negro, received a sentence of perpetual enslavement, but the underlying crime that John Punch committed was running away. He attempted to self-emancipate. Once slavery became entrenched, there were many cases of individuals who sought to emancipate themselves by escaping to freedom. They would flee to Canada or to free states in the North. And for a time, Florida offered refuge when it was controlled by Spain. But I want to focus on the paths to freedom that was sanctioned by the law and often resulted in the freed people remaining in the area where they had been enslaved. And again, there were always avenues to freedom before the Civil War. For example, this slide shows legislation that New Jersey enacted in 1786 to reward an African American for his service in the Revolutionary War. For decades before the Civil War, enslavers were free to emancipate the enslaved on terms of their choosing. And hereditary slavery law was enacted in 1662 in Virginia, presumably in response to lawsuits brought by people born to enslaved women, but who sued for their freedom on the basis of the race of their English fathers. The English common law determined a child's social status by reference to that of the father. This 1662 law that determined the status of a child by reference to the mother was put in place to accommodate slavery, but it also provided for the freedom of the child of a free mother, even if the father was an enslaved man, and the descendants of that child would be born free if born to a free mother. This is an excerpt from an 1814 South Carolina deed of emancipation by which an enslaver named Mary Arnold manumitted an enslaved man named Matt in Lawrence County, South Carolina. Before 1800, a record like this might not have existed because an enslaved person in South Carolina could have been freed by a will on the death of the enslaver or by any other, quote, thing that showed that the owner had deliberately parted with his property, end quote. 1800 legislation provided that emancipation could only take effect by deed. An enslaver appeared with the enslaved person before a justice of the peace and 5 freeholders, landowners in the neighborhood. All of the parties were required to endorse a certificate upon the deed to confirm that the enslaved person was not of bad character and was capable of earning an honest living. The list on this slide includes all of the states for which slave schedules were compiled in 1860. It was included on a map that can be found on the census.gov website. On the eve of the Civil War, there was quite a large population of enslaved people, especially in states such as South Carolina and Mississippi, where enslaved people represented over half of the population. There was a continuing fear of slave insurrections and laws that were presented as public safety measures were enacted to control the population of the enslaved. These public safety laws had the effect of restricting the ability of slaveholders to emancipate enslaved people. The historian Ira Berlin reported that by the 1850s, only the border states of Delaware, Missouri, and Arkansas gave slaveholders free rein to emancipate the enslaved. And Arkansas eventually prohibited emancipations in 1858. This 1820 South Carolina law provided that the only way a slave could be emancipated was by act of the South Carolina legislature. So-called public safety measures were also enacted to limit the number of free people of color in a slave state because they were thought to be bad influences on the enslaved population. Where emancipations were allowed, a formerly enslaved person might face a provision like this Virginia law that forced them to leave the state or be re-enslaved. This type of provision served to discourage emancipations that would result in the separation of families where some family members remained enslaved. The Ordinance of 1787 established the Northwest Territory, now the states of Ohio, Indiana, Illinois, Michigan, and Wisconsin. It purported to ban slavery in the area north of the Ohio River and east of the Mississippi River, but was routinely evaded or avoided. All of the states of the territory, except Wisconsin, adopted legislation designed to subjugate African Americans, free or enslaved. And you will hear more about that kind of legislation in Dr. Abbott's lecture. This excerpt from an article found on JSTOR describes a 1778 Virginia law that provided for the emancipation of enslaved people who were imported into Virginia. But this law appears to have been aimed at slave traders who transported people for sale, because it did not apply to enslavers who migrated to Virginia and brought enslaved people with them, if the enslavers intended to become citizens of that state. People tend to associate the northern states with anti-slavery abolitionists and only the South with slaveholders. But slavery existed in every British colony, and slavery in the North persisted into the 19th century. This chart shows the growth of slavery as tracked in the first US Census in 1790 through the 1830 US Census. No slaves were listed in the first federal census of Massachusetts in 1790 because in 1783, that state's highest court simply did away with property rights in human beings. In 1783, in a series of cases that are referred to collectively as the Quock-Walker case, the highest court in Massachusetts interpreted the state constitution to mean that slavery had been abolished by the declaration that, quote, all men are free and equal, and that because this language was intended to accomplish the liberation of enslaved people, no additional legislation was necessary. Slavery was also practiced in areas that were not originally settled by England, such as New York City, which was settled by the Dutch. This 1810 census record shows male and female slaves in the city and county of New York. Keep in mind that Vermont declared itself an independent republic during the American Revolution and was not admitted to the Union as the 14th state until 1791. So technically, it was not the first state to start the process of gradual emancipation, but it was the first jurisdiction to craft language intended to implement gradual emancipation. One of the issues that Vermont addressed was whether and how to compensate slaveholders for the loss of their property rights in people. And there really is nothing new under the sun. Vermont followed the approach used in other countries at other times, such as Canada. People forget that there was slavery in Canada. And that approach was to delay emancipation so that enslavers would have the labor of these people during their productive years. There's literature suggesting that this delay was a benefit to the African Americans because it provided the opportunity for training and socialization before they entered society. But every debate over emancipation in the Americas involved some discussion of compensating slaveholders. The Vermont provision made a distinction based on gender, granting emancipation for males at age 21 and for females at age 18. but it also allowed voluntary servitude or enslavement. And for compulsory slavery, due, for example, to non-payment of debts. Well, the Vermont constitutional provision had a huge loophole because enslavers could sell people to a jurisdiction that allowed slavery. In 1786, the Vermont legislature enacted legislation to prevent slaveholders from evading the law by transporting and selling enslaved people out of the state. Before that enactment, a research subject might have been born on Vermont soil and entitled to freedom, but sold away to a state where they would continue to be enslaved. So with the exception of Massachusetts, none of the northern jurisdictions simply abolished adult slavery. The original enactments in other states followed Vermont's lead. Pennsylvania holds the distinction of being the first state to enact gradual emancipation legislation. New Hampshire was not included in this table because although its 1783 Constitution included language about natural rights, similar to the words interpreted by the Massachusetts Supreme Court as being incompatible with slavery, no specific legislation was ever enacted, and it's unclear whether slavery was legally abolished in New Hampshire before adoption of the 13th Amendment to the US Constitution. New York had more enslaved people than any of the other northern states. In 1797, 1 in 5 households held at least one person in bondage. And this is probably why it was the next to last northern state to enact gradual emancipation. New Yorkers had more to lose. New York enacted a series of staggered dates. In 1817, however, the law was changed to emancipate all enslaved people, but implementation was delayed for 10 years until 1827. Although Pennsylvania was the first of the original 13 states to enact gradual legislation, emancipation legislation, the Pennsylvania law was the most restrictive of the 5 laws passed by northern states. Emancipation was limited to those born after March 1, 1780, and the emancipated person was required to serve the enslaver for 28 years. There were enslavers that took the position that if a child was born during a mother's service, the child itself could be held for 28 years. And that went on until 1824, when the courts decided that the only people who could be held in servitude for 28 years were those born to enslaved mothers. And you will recall that the English colonies had reversed the normal rule under which the status of a child followed that of the father, so that children born to an enslaved woman were enslaved at birth. The Pennsylvania Gradual Abolition Statute expressly provided that children would not be treated as slaves in consequence of the slavery of their mother. Instead, they were treated as indentured servants. People who were enslaved before the effective date of the 1780 law were to remain enslaved for life. However, as late as 1847, Pennsylvania finally enacted legislation to free all of the enslaved. So if your research subject was in Pennsylvania before 1847, his or her status depended on the year of birth, and if applicable, whether the statutory indenture had been served. And I should also mention that because Pennsylvania was serving as the seat of government, it was where the Congress met under the Articles of Confederation. An exception to all of those rules was made for people enslaved by members of Congress. And of course, enslavers sought other ways around the legislation. For example, pregnant women were sent out of the state so their children would not be born free in Pennsylvania. 1788 legislation attempted to close the loophole, including by providing that pregnant women should not be sent out of state pending delivery and requiring the registration of the birth of a child to an enslaved woman. The Pennsylvania statute also addressed the issue of slaveholders who didn't want the responsibility of supporting an infant who was born free, even with the enticement of obtaining the child's labor until age 28. The mother's enslaver could abandon the child to the overseers of the poor, and that authority could bind the child to an indenture for the prescribed 28 years. So 1840 was the last census that enumerated enslaved people in Pennsylvania, when less than 100 were enumerated. Connecticut enacted legislation in 1784 with a less generous to slaveholders 25-year term of indenture for people born after the effective date. And they reduced the age of emancipation from 25 to 21. But Connecticut didn't attempt to interfere with enslavers who brought slaves into and out of the state in transit, so they could come and go out of the state at will. And all enslaved people were not freed until 1848. Rhode Island presents an interesting case because it played such a huge role in the transatlantic slave trade during the colonial period, when Rhode Islanders held more enslaved people per capita than any other New England state. So the General Assembly of Rhode Island passed a gradual Emancipation Act in 1784. And that legislation kind of tracked the Pennsylvania statute. And instead of obligating the freeborn to serve the enslavers of their mothers, the financial obligation to support those children was placed on the town where they resided, although the town could bind them out as apprentices. Now, for the general population, no births were recorded in New York State before 1847. But similar to the requirements in other states, over 40 years before 1847, New York's gradual emancipation law required the creation of birth records for children born to enslaved mothers. And this slide shows a birth record for a female child named Isabella, born to an enslaved woman in 1802. New Jersey was the last northern state to enact legislation in 1804, and the only one for which an 1850 census slave schedule was created. 236 enslaved people were enumerated. New Jersey was also the only state in the North to actively enforce the 1850 Fugitive Slave Act. But all enslaved people born before the effective date of the act were to remain slaves for life. Children were slaves for a term. So the last child registered under the New Jersey gradual abolition law was a girl named Hannah, born in 1844. Similar to the provisions enacted by other states, slave children could be abandoned to the poorhouse, and once abandoned, they could be bound out. Let's see. This is a birth certificate of a child born to an enslaved mother in New Jersey in 1806. New Jersey did not require statewide registration of all births until 1848, but births of children born to enslaved women began over 40 years before that date. There's a 2012 National Genealogical Society article by James Petty. It's cited in the handout, and it flags a New Jersey issue that is dealt with at length in a later 2014 article published in an historical journal and cited on this slide. Petty indicated that some slaves appeared as apprentices in the 1850 US Census free schedules. He provided an example of an individual who was enumerated as free, where records indicated that the manumission did not occur until 1853. And the 2014 article cites a case where a woman was enumerated as free in both 1840 and 1850, but was, quote, sold as a slave for life, end quote, in 1856. In the District of Columbia, enslaved people were freed about 9 months before the effective date of Lincoln's Emancipation Proclamation under a congressional law that provided compensation to their owners. Slaveholders could claim up to $300 for each enslaved person. The Slaves Claims Commission was created by the War Department to compensate the owners of enslaved men who enlisted in the Union Army. Only Union-controlled slave states were eligible. Delaware, Maryland, Kentucky, Missouri, West Virginia, and Tennessee. A slaveholder could offer his or her enslaved person, man, for enlistment into military service and become entitled to compensation in an amount not exceeding $300. But the slaveholder had to file a valid deed of manumission freeing the person and provide proof of ownership in the form of a title. It was basically an effort to get slaveholders in those states to voluntarily emancipate the men they enslaved. Michael Haight has published books on this record set, and they are cited in the handout. And he reported that in Maryland, for example, there were a relatively small number of payments made to the first generation of claimants in 1863 through 1864. But the vast majority of the claims came after the end of the war, and no payments were made to those claimants. And with that background, we will now hear from Dr. Abbott.
Am I here? Yes. Let me see if I can get my slides up. And I think I can. How are we looking?
It says you started screen sharing, but I don't see your slides yet.
Okay.
Ah, there they are.
They came up?
Yes, looks good.
Okay. Now let me get up. Good morning, everyone. Can you hear me? I think I'm okay. Good morning. I am going to talk to you this morning a little bit about free people of color in the North, but concentrating mostly on the Northwest Territory. As you all know, I am from Ohio, and I did have a person that I was researching that was giving me a lot of trouble. And it really helped me to learn about free people of color in the Northwest Territory. And so I want to start. I've got, of course, if you've heard me talk before, you know I always have a little small case study, and I do have one here as well. But let's get started. Did it move? All right. I always want you to think about what you need to do to prepare to do the research. LaBrenda has given us so many things to think about and so many laws and history that we need to make sure that we understand what's going on around our ancestors. So we should never, and she's mentioned this, probably assume that our ancestors were enslaved, because all of them were not. I always suggest that you check that 1860 census and to look beyond that if necessary to see what the status is of your ancestor. And then once you find what the status is, then at least think about, if they were free, how did that happen? Even in the North, how did that happen? There were approximately 200,000 free Blacks living in the North and 288,000 in the South. And I don't think we really understand that concept that all free people were not in the North. There were some in the South. And then my usual term with everyone is, no matter what we do, become that genealogy detective. Become familiar with state statutes. That's important, and LaBrenda has already emphasized that, so I won't go through the state statutes. Understand the Black codes and laws, court systems, understand what records are held where, so you need to be familiar with those historical societies, and you need to understand social histories You need to understand government records, and don't forget your libraries, and then manuscript collections, which I'll talk about later on this morning. Understand the history. I can't emphasize that more. And I think that if you listened to LaBrenda earlier, you will understand the necessity to understanding the history. There is a website that I use often, and it's blackpast.org. And I use it because when I'm looking for something that I'm not quite sure of, like, were there Black codes in Ohio? Were there Black codes in Indiana? I can go to that site and search that and get the answer fairly quickly. So if you have not looked at that, it's not a complicated site, and I think it's very simplistic, and it may help you when you're not quite sure of what you are looking for. If the Free People of Color book, I think I have that in your handout, and it talks about pre-Civil War in the North, and I thought it was important that you may want to put that on your list of readings. And it talks about the diversity and of free Black societies in the northern cities, and the psychological interior of what's going on with free people of color in the North. LaBrenda mentioned the Fugitive Slave Acts, and as I looked at these, you need to know, if you don't already, that there are two of them. One is 1793. It was written with the intention of enforcing the U.S. Constitution, and it required the return of runaway slaves, and it sought to force the authorities in free states to return fugitive slaves to their masters. And so with that being said, you would understand why even going to a free state, an African American was really not free, because they could be returned at any time. The Fugitive Slave Act of 1850 made it official for federal marshals or other people who did not arrest an alleged runaway slave liable to a fine of $1,000. And that is a lot of money. In the state of Ohio, we had a lot of, or more probably, abolitionists than any state in the Northwest Territory, and I'll talk about that in just a minute. We had more abolitionists there, and so we did a lot of sheltering runaways and trying to keep safe those who had come into the state, even though they may have been free when they came. We tried really hard, the abolitionists did, to try to keep those individuals safe and out of harm, and to be able to shield them from being recaptured, I should say. And we had a senator who was fined many times because he was in Sandusky County, Ohio, and he hid slaves so that when the slave owners or the federal marshals would come through Ohio, they would not pick up people who they thought needed to be returned. Here's an example, and I just wanted to show you this one very quickly. This is a woman by the name of Sarah Lucy Bagby. She was born in the early 1840s. I think we have on record 1843 or so, and she was born in Virginia. And she was purchased by a gentleman by the name of John Gosshorn, and he purchased her in 1852, and he got her from a slave trader, and he paid about $600 for her. Excuse me. After owning after owning her for about 5 years, he gave her to his son, who was William Gosshorn. And you can see a picture, that was the best picture I could find of William. But during 1860, in the fall of 1860, Lucy was able to run away, and she escaped Virginia and she went north to Pennsylvania. When she got to Pennsylvania, she made up some stories. And because she felt that she was in a free state, it meant that she was free, and she didn't worry so much about going back to slavery. She eventually made her way here to Cleveland. And here in Cleveland, she worked as a domestic for one of our congressmen, Albert G. Riddle. But in 1861, the federal marshals came with William Gosshorn, and captured her. And the intent was to return her to William, to her master. This event went to trial. And so I'm saying all of this for you to understand that the records in the courts are just as important as understanding the laws and what could happen to an individual who was enslaved and then freed. They went to court. She probably had the best representing her. And Rufus Spaulding, he was a former Ohio Supreme Court judge, and Albert Riddle was her employer. And the judge for this case was Daniel Tilden. She lost the case. So she was returned to Virginia to be with the Gosshorns and was not able to leave there until the end of the Civil War. She left, went back to Pennsylvania, she came back to Cleveland, Ohio. She is buried here in Cleveland. Sarah Lucy Bagby Johnson is the last person to be prosecuted under the fugitive slave law of 1850. So let's look at the Black codes. And we usually think about them, at least I did, as being passed by Southern states. And it was something that I thought was only for Southern states. And I knew that it restricted freedom, but there were also Black codes and laws in the Northern states that did the same exact thing, same thing. Black codes were part of a larger pattern of Southern whites who were trying to suppress the freedoms of emancipated African Americans. Black codes were also enacted in Northern states, such as the ones I'm going to talk a little bit about this morning: Ohio, Illinois, Indiana, Michigan, and so forth. And prior to the Civil War, it was used to ban free Blacks from residing in these states. So I'm suggesting, with that information and what LaBrenda talked about this morning, that you make sure that you research county courthouses. You need to look for registers, and we'll talk about that. You need to research land records and property deeds, and even tax records if it's necessary, and to search for the manumission papers if you find that the person you are researching was indeed free. So let's talk a little bit now about the Northwest Territory. The Northwest Territory, before its creation, there was the Northwest Ordinance of 1787. It has had several titles. The official title was an ordinance for the government of the territory of the United States Northwest of the River Ohio. It was adopted by the Confederation Congress on July 13th, 1787. It established a government for the creation of the Northwest Territory. It outlined the process of admitting a new state to the Union, and it guaranteed that newly created states would be equal to the original 13 states. And it was considered one of the most important legislative acts of the Confederation Congress. The Northwest Ordinance also protected religious freedom, the right of trial by jury, and in addition, it encouraged education and it prohibited slavery. You can find more of this information on the Northwest Ordinance at the Library of Congress. And I've tried, I hope you can see it, it's small, but I wanted you to be able to see just where the Northwest Territory was and how it connected with the British North America, which was Canada, and Spanish Louisiana, and parts of Kentucky. And then you can also see that Pennsylvania is just right on that eastern edge, and it's right below the Great Lakes. So when we look at the entire country, here you can see the outline of the Northwest Territory. This is the area that I'm going to talk a little bit about and to show you a case study that comes out of the Northwest Territory. So this is the map so that you can see it. And this map, it was easy to find. It was in the Wiki Commons. And so you can check that when you're looking for maps and things like that, that you can use in your family histories. Here's a closer look at what the states were that came out of the Northwest Territory. So you're looking at 1787, and you have 5 states. You have Ohio, Indiana, Illinois, Michigan, and Wisconsin. And they were organized with a small part of the land between the Mississippi River, St. Croix, and the Mississippi River. And between that, we have the incorporation of Minnesota. So you can see Minnesota up at the very, very top. Ohio, and I'm leaving it for last, but Ohio was the first state to come out of the Northwest Territory. And Ohio was, when it created its charter, and we'll talk about that, it followed the patterns of Virginia, and the other states followed Ohio. So we're looking at states that, to me, at least appear to be almost slave states in terms of its treatment of African Americans. But in 1852, the General Assembly moved to enforce articles in the Constitution for Indiana, and it barred the immigration of African Americans to come into that state. They required people who came there to record themselves with the county clerks, and they were to maintain a register of Negroes, and the courts were to keep that record. And the registers would include the name of the person, the age, physical description. And when we look at the difference later on of Indiana and Ohio, Ohio did recognize African Americans as free men, while whites in Indiana wanted them to be slaves. And so there's a lot of how can I say this? Let me think about it. I'm losing track of my thoughts. But just as, let me go on, just as most places, most of the states, the registers of the free men who came into the state of Indiana were kept sporadically, and they were kept that way for the state of Ohio as well. The archives for the state of Indiana holds the registers for Switzerland, Clark, Franklin, and Ohio counties. You may check the courthouses in the other counties to see if they too would have registers, or if the archives, the state archives, might have those registers. In Illinois, slaveholders started transporting African Americans or slaves into Indiana territory, and they were required to register them. So there's going to be, if you can find them, registers of African Americans who were coming from the South and traveling through Indiana. And they too had to register with the clerk of court of common pleas. Illinois created an indentured servitude system that required any slaveholder coming from the South who wanted to set free their slaves. And with that, those individuals would have to pay $1,000 bond for each person. In the state archives of Illinois, you will find a collection that is Illinois servitude and emancipation records, and they go from 1722 to 1863. Michigan's creation in 1837, they had a very small Black population. So you would think that they probably did not need to have Black codes or Black laws because their population was so small. But they too adopted Black laws, and they kept African Americans segregated just as effectively as the other states. And the experience of Blacks in Michigan was not very easy, was not good. And the white citizens there, they feared African Americans, and they transferred that fear from one generation to another. African Americans in the state of Michigan, as in a lot of other states, had to produce freedom papers before they could go to work or have legal residence. State law required each African American to sign a registry, and that too was kept in the clerk's office. Those eventually are what we're calling Negro registers. Wisconsin was the last state formed from the Northwest Territory. They adopted a Bill of Rights that included a prohibition against slavery. But unlike the other states, they never adopted a comprehensive list of Black laws, and they became a state in 1848. Now for Ohio. Ohio's Constitution of 1803. We were the first state to come out of the Northwest Territory. And we followed the Constitution of Virginia. And in Virginia, slaveholders who brought slaves into Virginia were required to register the property. That is the same thing that Ohio did. It required all free African Americans to register with the county clerk. This constitution also allowed white men to vote if they paid taxes or helped maintain the state's roads, but it failed to give that same privilege to free Black men by just one vote. The law prohibited slavery, and they did that because of the provisions in the Northwest Ordinance that governed the Northwest Territory. No slaves were allowed in the Northwest Territory. In 1804, Ohio limited the rights of African Americans. Number one, they had to post a bond, 12.5 cents when they arrived in the state. They couldn't vote or hold public office. They couldn't testify against whites in court, and they can't join the state militia. They could not be in the army, nothing military. And they were not allowed admittance to state poorhouses, insane asylums, hospitals, and etc. So even though Ohio was considered a free state, these laws in 1804 remind me of slave states, Southern slave states. So if this wasn't bad enough, in 1807, we just had a continuation of our first Constitution and the laws that we created in 1804. And we required people who were coming into the state to prove that they were not slaves or they were not runaways. So they passed a series of laws to discourage African American migration into the state of Ohio. And this went on for the next, I'm going to say probably the next 40 years. In 1803, in 1804, 12.5 cents was the bond that you had to pay for every person who came into the state of Ohio. With this 1807 law, now you have to find at least two white people who will vouch for you, who will guarantee a bond of $500 that you are going to be on your best behavior. This law also limited rights for African Americans to marry whites. And it also limited their ability to own guns. The law made African Americans vulnerable to abuse, and it ensured that they could not rely on the courts for protection or justice. And as I mentioned earlier, these Black laws in the state of Ohio were repealed in 1849. There are several books out there that you can read about Black laws. Black laws of the Northwest, Black laws in Ohio, Illinois, Michigan, Wisconsin, not Wisconsin, because there are no Black laws for Wisconsin, but Indiana. And these books are in your handout. So I would suggest that you might want to take a look at that. We're going to look at a study, a little short case study from Logan County, Ohio. And I just wanted you to know that as I read, I learned a lot. 1850, Logan County, Ohio had the third highest percentage of free Blacks, about 13% of those states in the Northwest Territory. A lot of the people who lived in Logan County, African Americans who lived in Logan County, of course, came from other places, born in other places. Of that 13%, we had Ohio with about 276. North Carolina, they had 117 people. 110 came from Virginia, 6 from Maryland. Pennsylvania had 4. And then there were 4, believe it or not, from Canada, 1 from Kentucky, and 1 from Michigan. And the free Black population in Logan County, Ohio, just was spread around that county fairly evenly. We're going to look at a township called Monroe Township. And there were about 105 African Americans in Monroe Township that were from Virginia. And we're going to look at those people. I wanted to share with you this Negro register that I found in 2 places. One, I found it in, of course, Logan County, Ohio. And I also found it in Northampton County, South Carolina. And this is for an Everett Byrd. And it is the Justice of the Peace in Northampton County, South Carolina. And he is saying that he knows and he's certifying that Everett Byrd is a free man of color. He also says that he knew his mother. He also says that his grandmother was a white woman, and that Everett Byrd was free and had been free basically all of his life. The date of this is March 1835. This is the document that Everett had in South Carolina, in Northampton County. And this is the document that he filed when he came to Ohio, to Logan County. Here's another one I wanted to share with you. This is from Miami County, Ohio. And this is Betsy Jackson. And she is one who had to have 2 white people to vouch for her. And this document is in our state archives, which is the Ohio History Connection. And it is her registration. See if we got that. Yep. And she has been working in Miami County, Ohio. And the 2 people, that one person that she worked for and another one who was a good friend of the one she worked for, they were the ones who vouched for her and said that she was going to be a good citizen and paid that $500 bond. And in that document, it says that Thomas Barrett and David Jenkins, they are bound to the state of Ohio in the sum of $500, which they made on their own, not under force, and that they bind themselves and their heirs to the fact that Betsy Jackson is going to be an honorable citizen for the state of Ohio. And again, this one is dated October 18th, 1837. There are written books for Negro registers. Alexander County, Virginia has in print free Negro registers. It'll tell you what's in the documents and where you can find them. Indiana also has one. All of these should be in your handout. Pennsylvania County, Virginia has it, District of Columbia. And then for Ohio, we have the Register of Black, Mulattoes, and Poor Persons in 4 counties, from 1791 to 1861. I wanted to also share with you that Ohio has Virginia militia territory. And so where you see this green, I think you can see it here, this little section, this is where you're going to find Logan County. And it is in the Virginia Military Survey of the state of Ohio. And you can see how Ohio is all divided up. And that's for a different lecture. But there was about 4.2 million acres of land in Ohio that was reserved by Virginia to use as payment for the Revolutionary War to soldiers in lieu of cash. American Revolutionary War in lieu of cash. A lot of the soldiers who received that land did not come to Ohio. They sold it. And so I wanted you to understand about that Virginia militia land. The owner of it did not come to Ohio. He sold his section to others in Ohio, including an African American. The map next to this is this green section, all of this divided into counties. And here at the top, up here, is Logan County. Okay, let me try to hurry through this. The person that I researched was a James Hicks, and you can see him up at the top, and you also can see that he's got land. And so that's what jarred my attention and said, I need to know where that came from and how did he have so much just in 1870. I found his obituary in the newspaper, and I found it, and it gave me some hints about this James Hicks. First of all, it told me who his mother and father was, Jason and Mary. It told me that he came to Ohio around 1835. Because of the land, how much land he owned, I checked to see if there was a biography on him, and there was. And in that biography, it told me how much land he had, 151 acres, and it told me where it was. It was west of a town called Pickerel Town. I checked the deeds for Monroe Township, Ohio, found the land, and I'll show you that where where his land was. And it had been owned by a gentleman by the name of Holland Hanley. That was the Revolutionary War soldier. And I think you can see that. Here's the map. Part of that land that Hanley owned was number 3222. And you can see James Hicks right here. And these are his neighbors, and I used those neighbors to also try to make sure I was looking at the right person. And here is Pickerel Town, right there. All that land was owned by Hanley. So I find him in the 1870 agricultural schedule. And then I thought, we need his father, because I want to see if there's a register for them. His father is Jason. I find him in 1870 based on the information that I had. I look for Jason in 1840. I find him there. He's got a little bit of property too. And he is in Monroe County in 1840. So that led me to try to locate a register. I found the register for James Hicks's father, Jason. And he is coming from Southampton County, Virginia. And it has his description. It tells us what he looks like. He's about 27 years old in 1835. He's 5'7". And it also tells us that he was born free in Southampton County. The book, yes.
We are getting near to where we will have to wrap up so that we can prepare for your next class.
I'm good.
Um,
I'm good.
did you either of you want to have any follow-up statement before we go?
None from me. Is there any burning question that you noted that one of the participants wants answered?
I'm going to post 3 of them.
Okay.
And give you a minute to look at those. Those are the spaces between them. I mean, that's 3 different questions.
But I'm not looking at them. I can't
Oh.
see them.
Oh, look at your chat.
Oh, okay.
Well, let me just handle one of them while Debbie's looking. The last question is, how common was it for enslaved people who are manumitted in a will not to be freed? And she's researching people enslaved by her husband's family. And I can say that I have certainly seen cases in South Carolina in particular, where people provided for the emancipation of people in their will when it was still allowed to do it that way, where the heirs of those folk took them to court. Sometimes they won, sometimes they didn't. And I like to point to the example of President George Washington, who had a 29-page handwritten will that anticipated that his heirs might do something like that. And his will was kind of an airtight document that prevented them from doing it. So yes, because enslaved people were valuable property, you could count on, in many cases, people challenging the will where the enslaver desired to emancipate people. Debbie?
I was going to say, let me add on to that in terms of John Randolph. John Randolph was I think a congressman in the U.S. Senate. He too left a will where he freed 300 slaves. And he also had left instructions to purchase land in Ohio. And just as LaBrenda mentioned, his heirs fought the will, and it stayed in court for 12 years. And so eventually the slaves that he was trying to emancipate were set free, brought to Ohio, because the administrator purchased the land, brought them to Ohio, but the whites in Ohio did not allow them to come onto that land. And those slaves from John Randolph end up going in other places. And so some of them, yes, were freed. Some had died in that 12-year period. But again, when I see something like that, then I know that there probably is going to be a court case. So I'm going to look at the courts. So I'm like LaBrenda for that.
And for the other questions, I just would encourage people to look at our handout where we try to include additional resources that might help you find answers to those questions.
Well, thank you so much. This is a wonderful presentation. I've been a student of the Civil War since I moved to Georgia when I was 9, and I will certainly read more the materials I have and the new materials you presented. Thank you very much.
You're welcome.
And we must go, so I'm going to end the session and check out the session page for the downloadable resources. And remember, this was recorded. And thank you very much.
Thank you.
Thank you.